and welcome to the San Francisco Superior Court Real Property Department. You have already had a chance to meet Judge Haynes, who is the presiding judge in this department in the first part of this video. My name is Olga Grikova, and I'm the staff attorney for this department and actually for the court in San Francisco Superior Court. This is known as the Real Property Department. However, today, I will be mostly talking about unlawful detainer proceedings because they move really fast and you need to get the information relevant involving unlawful detainers, also known as evictions. If you're an attorney, you probably already have all of this information. If you're representing yourself, this will be a great starting point for you to know what to expect in this department when you appear for various calendars here. Usually, any civil litigation starts with filing of the complaint for the plaintiff and with service of the complaint and the summons on the defendant. And usually, every case ends in a judgment. There are a lot of little steps along the way that the parties may take to resolve their case. And those little steps are an ex parte application, a motion, or a trial. All of them start with one of the parties or both parties making a request to the court. You need to file your papers. The other side gets an opportunity to oppose. The judge then considers both parties' statements, oral and written, and issues an order. And that's how the case proceeds. At this point, I will talk about the fastest, the quickest, and usually the simplest application made to the court, which is an ex parte application. The ex parte applications are made at ex parte calendars, which are held every day on Monday, Wednesday, Thursday, and Friday at 9 a.m. and on Tuesday at 10 a.m. For these applications, the moving party will let the judge know what it is that they want, and the opposing party will tell the judge if they agree with the request or oppose the request. The moving party always must file moving papers. The opposing party has an opportunity to present their opposition orally. The judge will consider both the moving papers, the opposing papers, and oral argument and issue a ruling. Ex parte applications are designed for extreme emergencies or for something simple. For example, if parties agree on something and just want the court to sign off on it, or the emergency may be an eviction scheduled for next day, and you're coming to court to ask for a stay of that eviction. That's an emergency that the court will consider on ex parte basis. The party who is requesting relief from the court needs to give notice to the other side about their request. And that notice needs to come at least before 10 a.m. the day before the hearing. It may be later. However, you will have to have a very good reason for providing notice later than 10 a.m. the day before. The court will want to know that you gave good notice before the court can proceed with the merits of your application. This is especially important when the other side does not appear. The cornerstone of the due process is notice and opportunity to be heard. Judge Haynes, just as any other judge, takes that extremely seriously. You may not be heard if you did not provide good notice and did not give the court a declaration regarding that notice. Be very careful about that. The opposing party may file papers with the court, but is not required to. The court understands that you may not have enough time to do so since the notice is so short. You will be heard orally at the ex parte hearing. Please come prepared. Please make sure that you filed all your papers with the clerk's office that is located in room 103 in the courthouse, located at the 400 McAllister, San Francisco, or you may file it online. The online process is a little complicated, and if you're representing yourself, it may be easier for you to just file the papers in the courthouse physically. You also want to have an extra copy for the court. That extra copy has to be delivered to the court before 9 a.m. on the day of the hearing, and the court will make a list of all ex parte appearances based on the courtesy copies received from you. Sometimes the ex parte calendar may be long. Sometimes it's very short. So be here on time. The on time is at 9 a.m. Monday, Wednesday, Thursday, and Friday, and at 10 a.m. on a Tuesday. Your case will be placed on the list and then will be called, and you will have an opportunity to present your arguments. The judge will then make a decision. You will receive a written order if the application is granted, and if the application is denied, you will be informed so orally. You will then need to serve that order on the other side if you receive an order from the court. For your ex parte applications, please be prepared. If you are not the one who wrote the papers and you use the help of the Access Center located in the courthouse or Eviction Defense Collaborative, please make sure that you read the papers prepared for you. Know what is in the papers. If the court has any questions, you may just point to the specific paragraph of your papers, or you may orally respond. Also, if you're asked a question that you do not fully understand, please ask. Please just ask for clarification. If you need a little bit of time to go through your phone records or emails, ask for a break. You will be afforded an opportunity to get prepared. You will be placed at the end of the calendar, so at the time when the questions are being asked, you have enough information to provide the court to make a determination. And again, remember, ex parte applications are for something very easy or an extreme emergency. You only will be here for maybe an hour, and then you can be free to go about your day. That will resolve a discrete issue in your case, and the court will proceed with the rest of the case at a later time. Please do not forget that we do have resources available for self-representing litigants. We have an Access Center located in Department 509 in San Francisco Superior Court at 400 McAllister, San Francisco, California. Or if you are a defendant in an unlawful detainer, your best resource will be the Eviction Defense Collaborative. If you are a defendant in an unlawful detainer case, you will receive notification from the court with all the resources. When the case is filed, you will get a notice to defendant mailed by the court, and all the available resources will be listed there. Thank you.